Welcome to the Aero Export Consultants podcast. I'm John Young, and this is The Point. Last month, we took a look at when due diligence by U.S. exporters was able to save two companies from falling victim to an illegal diversion scheme to transport export-controlled products to China. It was a perfect example of end-user certification and careful examination of red flags that emerged during the transaction that ultimately resulted in protected U.S. technology and arrests of those who sought to subvert U.S. regulations. Again, it was a perfect example of what to do to avoid violations. Unfortunately, not every company is as diligent. Not every company avoids penalties. Sometimes things go wrong, and it's only after the dust clears do you realize that you've violated export control regulations, and the government has arrived with penalties in tow. For this month's episode, I want to focus on two such cases, where compliance procedures came too late or not at all, and resulted in a BIS penalty and ultimately a settlement with the government. Because just as we can learn from the success of solid export compliance procedures, we can learn from the failures that companies make as well. These administrative enforcement settlements both came out within the last few months, and coincidentally, both involve improper transactions with China. I swear, I'm not focusing on China purposefully. I know several of my recent episodes have been China connected. It just so happens that both of these cases are tied to exports to China as well. Though it's always a good idea to remind my listeners that China is an economic adversary. We have several targeted export compliance regulations regarding China, and we have an overall view of distrust and presumption of denial in several key technology sectors when it comes to trade with the PRC. But like I said, definitely not focusing on China. We'll start with the first case in the matter of the Solventum Corporation. And if you're wondering, the two cases I'll be going over are posted on the BIS website. I'm not revealing any information that the government has not already disclosed to the public. According to the settlement, between December 2023 and January 2024, the respondent caused, aided, or abetted violations of EAR regulations through the sale and transfer of EAR 99 items for export to Semiconductor Manufacturing South China Corporation, or SMIC South, a party on the entity list. Already, we can see huge red flags about this transaction just from the summary of the general allegations. Semiconductor industry, China, entity list. Three separate elements of the transaction that on their own would warrant a second look, but together should have warranted a pause of the transaction and a serious review of it entirely. Additionally, it appears that the 2023 case wasn't the only violation discovered either. In whatever investigation accompanied this case, internal or external, the settlement also reveals that back in 2021, there was an additional illegal transaction involving the export of EAR-controlled products to a sanctioned entity in China. This time, the Ningbo Semiconductor International Corporation, or NSI, also identified on the entity list. Again, three red flags: semiconductors, China, and entity list. Now, before I get more in depth into these charges, if you noticed I said earlier that the items in question that were exported were classified as EAR 99. I want to take a moment and talk about that because I fear there is a misunderstanding of EAR 99 in the manufacturing and exporting community. EAR 99 is the lowest level of control on commercial products, and is viewed as no license required for most end users and end users. Many products fall under this classification. However, there is a dangerous trend in manufacturing to assume products will fall under EAR 99, and a continuing dangerous trend of assuming licenses will not be required for your transaction. Proper classification is vital for export compliance. We have to remind our clients of this occasionally and always try to verify classifications when we get the chance. And even if the classification does turn out to be EAR 99, that does not mean that your work is done for compliance procedures. This case will clearly show how even EAR 99 products can sometimes require licenses, and failing to account for that can result in compliance violations and civil penalties. So let's set the scene in this case a little bit. According to the statement of charges, prior to the violations and unrelated transactions, the respondent had applied for and received unrelated licenses from BIS to export EAR items to SMIC South, and it appears these items are the same as the ones in the violation. So that's actually surprising, and it does change the situation slightly. Presumably, these licenses were granted in full knowledge of where they would eventually end up, which means BIS determined at the time that these particular EAR 99 items posed a negligible enough risk to allow them to be exported to an entity-listed semiconductor manufacturer in China. It happens, I suppose. But it still doesn't change the fact that all of those factors, entity list, semiconductor end use, required a commerce license in order to export originally. Now, the charges don't mention what changed, But sometime after these unrelated transactions, BIS partially suspended the respondents' licenses for SMIC South in November 2023, and it does say that there was an internal review by compliance personnel to halt any pending shipments to SMIC South. From that point on, they were not allowed to export their EAR-99 products to the Chinese company. Their licenses were suspended, null, void, bunk. Despite this, and at some level knowing the end destination of these products, the respondent transferred the EAR-99 products to China in December 2023 and January 2024, violating export regulations. BIS picked up on this violation through EEI filing and managed to halt some of the products before they were shipped from the US. So what does this case ultimately show us? Well, a few things. First, it highlights again the importance of knowing your end use and end user. I mentioned this in last month's episode as well, but it really is one of the most important aspects of international trade. In this case, the end use was a semiconductor manufacturer, and the end user was in China. These two elements are automatic red flags. In the original transaction this company went through, they had BIS authorization, likely due to their products being classified as EAR-99. It still required a license, however. But trade with China is volatile and subject to change. Technology and our understanding of it evolves, potentially changing the government's view of exports, or maybe the company itself was under scrutiny, resulting in the licenses being suspended. Either way, the status quo was changed, and this company failed to adapt, even after a review was conducted. We don't know why or how the transaction managed to continue after this review. The case simply says the respondent failed to timely identify the transaction as ultimately involving the Chinese company. It was a failure of internal workings or communications on some level, and reminds us that transparency and communication of compliance red flags is vital. This case also reminds us that EAR-99 is not a blanket status on products. Just because your product is classified this way doesn't mean licenses or end user checks are not required. Scrutinize your transactions and your customers, even for your lowest classified products. Hearing about this case, you might be worried about your own potential violations. Without all of the details, this case might sound like a simple mistake that led to an overblown penalty. And if you were wondering what the penalty was for this case, it's in the amount of $1.6 million. But keep in mind, this company would have already gone through the licensing process for the original approved transaction. They would have already known this end user was on the entity list. They would have already known that a license was needed in order to export their EAR-99 products. They would have known that their previous licenses were suspended. They had a review that would have brought all of this information to light, and they exported these products anyways. Negligence is punishable by the government in circumstances such as these, as it should be. On that cheery note, let's switch over to our second case on the matter of Coastal PVA Technology, who exported products to, I kid you not, SMIC, though unlike the previous case, this case involves SMIC Beijing and SMIC North instead of South, so completely different. But let's jump in. According to the court documents, between, on, or about May 15, 2021 and May 19, 2024, Coastal engaged in conduct prohibited by the regulations on 18 occasions when it sold and exported items subject to the EAR to SMIC Beijing and SMIC North, both parties on the entity list, without the requisite license or other authorization from BIS. The products in question were EAR-99 products, alcohol brushes, and related products, but they can be used in the semiconductor manufacturing process to clean post-etched semiconductor wafers. So right away, we can see that these cases are extremely similar. EAR-99 products, but intended to China, specifically semiconductor manufacturing companies that are on the entity list, so a license is required. During the relevant time period, Coastal sold its brushes and related products to end users in China through 2 third-party distributors based in China. At times, even when it sold the brushes and related products through these distributors, Coastal in fact shipped the items directly to SMIC Beijing or SMIC North. At other times, Coastal shipped the items to the distributors, who subsequently transferred the items to SMIC Beijing or SMIC North. For all shipments, Coastal knew that its brushes were destined for SMIC Beijing or SMIC North. So there are some differences to take note of in this case. Coastal sold some of their products to third-party distributors. This is a potentially dangerous element that needs to be followed up on in transactions. The ultimate end user should have been known for all of these transactions. Just knowing the distributor would not have covered it. Although that is a slightly moot point in this case, considering the documents show that Coastal also shipped directly to SMIC. But the point remains for you listeners. Know your end user. Verify and check all parties to the transaction against denied parties lists. You have a responsibility as the exporter, so make sure you live up to it. In last month's podcast, we talked about the internal compliance procedures that saved some companies from violating export regulations, preventing the unlawful exports of control technologies, and saving companies from penalties. And in the last case as well, compliance reviews were mentioned, though they inevitably failed and resulted in penalties nonetheless. Unfortunately, for this case, we cannot expand on compliance procedures. We can't talk about their export compliance policies that might have protected them, or failed to protect them due to human error. The reason? Because it says so in plain black and white in the settlement documents. Quote, Coastal sold the brushes and related products at issue without identifying the need for a license because of inadequate compliance controls. Coastal had no formal export compliance policies or procedures in place at the time of the relevant sales. As a compliance professional, it hurts to read that. The docs continue to say that after receiving an inquiry from BIS, a senior executive at Coastal stated that Coastal was unaware that unlicensed sales of EAR 99 items to SMIC Beijing or SMIC North were prohibited by the regulations. Coastal ceased further sales to SMIC Beijing and SMIC North after being informed of the licensing requirement. They had no procedures, no compliance knowledge, no training, and no idea that they were doing anything wrong. It was simple ignorance that resulted in a U.S. company exporting products used in semiconductor manufacturing to a Chinese company on the entity list, a denied party. For that reason, they received a $1.7 million penalty from BIS. If they had solid procedures in place, they would have been able to prevent this from happening. They would have received a purchase order and begun end-user checks. Once they received information on the customer, they would have run them through denied party screenings, realizing that they were controlled on the entity list. They would have recognized that though their products were classified as EAR 99, a license would be required, and special attention should be paid to this transaction due to the involvement of semiconductors, a heavily regulated industry in export compliance. Ultimately, a license would be approved or denied. Either way, this situation would have been avoided entirely. I stress export compliance knowledge because of cases like this. This manufacturer probably thought, we manufacture brushes. There's no way we should have to jump through hoops to export them, right? So what if it's China? We trade with them all the time. But the reality is we have these regulations for a reason. They're not just brushes. When used by China, they are a component of the overall industry of semiconductor manufacturing, one we are in a desperate arms race to dominate against China. And China's ability to acquire U.S. technology to further their aims helps keep them in the race. I wonder at that classification of EAR 99 as well. If the documents are correct and Coastal had no procedures at all, were they the ones who classified their products, or was it BIS after the fact? In other words, could this have been so many times worse if the products had instead been classified much higher and exported without care just the same? What if they were actual computer chips that were exported instead of brushes, and this company had no idea the potential dangers of such a transaction, selling to a barred company highly controlled technology? Thankfully, that hypothetical remains a nightmare and not a reality, at least not for this case. The penalties in this case also contain a difference to the previous one. Likely taking into account Coastal's complete lack of export compliance procedures, Coastal's $1.7 million penalty is suspended for a period of 1 year from the date of this order, and thereafter shall be waived, provided that during this probationary period, Coastal has otherwise complied with the provisions of the settlement agreement and order, including conducting export control compliance training and completing an audit, also ensuring that no other violations are committed moving forward in this period. We see this in a lot of cases, actually, where the government suspends part of the penalty and ultimately waives it if they see the company in question completing audits and buffing up their compliance procedures in good faith. It's part of the reason why we highly recommend voluntary disclosures at AEC, since voluntarily approaching the government and admitting your violations, while also explaining how they happened and committing to solving the issues and improving compliance knowledge and procedures overall, are seen as mitigating factors. Mitigation can reduce or even remove penalties entirely, depending on the scope and damage of the violations in question. So if you have discovered any violations in your business, disclose them. The sooner, the better. What both of these cases has shown is that quality export compliance knowledge and procedures are absolutely necessary. That's why I'm glad you're listening to this podcast, and why Aero Export Consultants exists. If you suspect violations in your business and need assistance with disclosures, or if you're worried about your business's readiness for manufacturing and exporting controlled technology, if you have transactions you think contain red flags and want some assistance looking them over, contact us here at Aero Export Consultants. We're here for all your questions and export compliance needs. Here at AEC, our motto is research done right, compliance made simple. I'm John Young, and this has been The Point.